Good afternoon, everyone. My name is Jackie Gharapour Wernz, and I'm excited to welcome you all here with us today for a discussion of the many rapid legal developments facing schools as we respond to the outbreak of coronavirus disease 2019, or the COVID-19. For those of you who are not familiar with Franczek PC, we are a boutique law firm located in Chicago and focusing on education, labor, and employment law. We partner with educational institutions and employers across the state of Illinois on the full range of legal issues facing schools. For a little bit of housekeeping, you do have the ability to type and submit questions in the chat function near the bottom of your screen. And everyone on today's webinar will receive a copy of the webinar recording and this presentation. And you'll also receive a survey, which we very much hope you'll complete because we do take those responses very seriously. So with that, let's jump in. We have a fabulous panel of presenters today. So let me provide some brief introductions. So first of all, Shelli Anderson has practiced education law at Franczek for the last 21 years. And serves as general counsel to several Illinois school districts and private schools. Her practice focuses on labor and employment matters, collective bargaining, and providing training on a wide range of school issues, from sexual abuse and harassment, conducting investigations, and best practices in evaluations. Nicki Bazer is co-chair of the Education Law Practice Group at Franczek. Nicki focuses her legal practice on policy and governance issues, student privacy rights, teacher evaluation, teacher misconduct issues, educator license compliance, general public school compliance, as well as charter schools. As former general counsel at the Illinois State Board of Education, or ISBE, Nicki provides valuable insight and counsel to school districts on the regulations and reform initiatives endorsed by ISBE. And then our final panel member is Jennifer Smith. Jennifer is a member of the firm's executive committee, and her practice involves representing education clients on a wide range of issues, including matters related to student rights, athletics, special education, labor and employment law, and litigation. Now, before we get to our Q&A, I was hoping that each of our panelists could give us a quick 30-second overview of their thoughts of how school law has transformed over the past week or so in light of the coronavirus. So starting with Nicki, tell us, what are your just general high-level thoughts?
Good afternoon, everyone, and thank you, Jackie. Obviously, this has been an incredibly confusing and complicated time for all of our educators out there. So we applaud all of the work. We are all parents and are seeing this from the parent end as well, and you guys are just doing an amazing job, so we appreciate all the efforts. From the ISBE perspective, given my previous time at ISBE, I know that they are trying to balance the needs of students and educators across the state in a completely unprecedented situation. We know the guidance coming up from ISBE has been changing and at times confusing. And so, we're hoping and expecting more guidance from ISBE as we settle in for more of a long-term situation. We'll talk a little bit about that later in the Q&A, but our hope is that, as we have a little bit more time to settle in here, ISBE's guidance will solidify so we have a clear roadmap.
Thank you, Nicki.
I will pass it along to Shelli.
Thank you, and hello, everyone. I want to say that, really in the employment and labor realm in which I primarily practice, I have insight from all the districts we work in and how you're all working together. And I have to say, first and foremost, how impressed I am with how all of you are working to come together to put the students first during this crisis, whether it's from getting learning up and running to making sure the students and their families are getting meals delivered, and the focus on everyone collaborating and supporting each other from every position in the district through the Board of Education. It's really been an amazing thing to see. Obviously, many questions are still unanswered, and there's complicated issues that are likely to arise, especially after March 30th, if any days thereafter are not also considered active God days. And I think that's when we're really going to see a lot of people having to be very creative in solving some of these problems and how to continue education for kids and handle staffing issues. Right now, the issues, as you can imagine, we're seeing are around, how to best serve students, but also what to do about staff evaluations and the, pay and benefit issues that are arising as a result of this, and the specifics of which I'll get into in more detail during the Q&A.
Thank you, Shelli. Jennifer, tell us about your insights.
Great, and thank you, Jackie, for that introduction. It has been a crazy week, but there have been a few silver linings from my perspective. I think we're finding out that IEP meetings really can be very successfully done remotely. I've done 2 now, one of them with attorneys involved and the parents and non-English speakers, so we had a translator. It was via Zoom, so we were all in the little Brady box configuration on your computer. And I have to say, I've never been so happy and lit up to see opposing counsel in that little box. There was something about the situation that put everyone in a very collaborative spirit. It was probably the best IEP meeting we've ever had for that student. I've had other positive experiences this week in collaborating online, and I think there really is some potential to make some things work. And so that's been a silver lining.
Great. Thank you so much, Jennifer. So let's jump into our Q&A. We did ask our participants for questions, and we were so grateful for many of you who flooded us with so many questions. We are going to do our best to answer them all today as much as possible. And we wanted to start with some more general questions that we received, like, for instance, I don't even know what I need to know right now, or why is it so much harder to run a closed school than an open one? So we wanted to start there. Nicki, any initial thoughts for folks who are facing this unprecedented and challenging change in how education is being provided?
Yeah, absolutely. Thanks, Jackie. First, in terms of what I don't even know what I need to know right now, hopefully we'll guide you through a lot of the really pressing issues through our Q&A, our substantive Q&A in just a moment. So we're going to try to hit the highlights for you so that you do know sort of what those big issues are and can start addressing them if they need to be addressed. In terms of I love the question, I don't even, why is it so much harder to run a closed school than an open one? It's such a great question. And, you all are the educators in the virtual room here. Obviously schools, even more so than most workplaces, thrive on the collaborative work of educators, on the energy and the positive interactions between teachers and students. And, we've lost a lot of that in this process in terms of just the day-to-day work that our schools are doing as enriching environments. And so it is really hard to sort of try to figure out what your students need, what your staff needs, when you can't see them, when you can't talk to them face to face. So we know that this is really, really difficult, and you guys are making the most of a really, really challenging situation.
So as far as our substantive Q&A, just to give you a sense of our agenda, we're going to start with some more general interest questions, and then we're going to zero in on employment questions, followed by special education questions. Now, we did purposefully include all of these topics together in one webinar because what we're seeing is that there's a significant overlap before a lot of these issues. So with that in mind, let's start with our miscellaneous questions. So our first question relates to authority. We've seen a lot of ISBE guidance. We've seen the governor's executive orders come in one after another. So what is the authority for these documents, and are they all set in stone?
So this is Jennifer speaking. So the Emergency Management Agency Act does give the governor very broad powers in an emergency, which this certainly is, to do things such as suspend orders, rules, regulations of any state agency, also to control the movement of people and occupancy. So for example, if the governor orders people cannot be in schools or no more than a certain number of people can be in a room, it seems pretty clear that he does have authority to do that. Where things get murky, we think, for districts is particularly where you start looking in federal. So where ISBE guidance can certainly of state agency requirements. If the files a lawsuit down the road for a law, there's no guarantee that ISBE guidance would be binding in any way on the federal courts. They're probably going to be applying the federal standards. So clear right under state law to take some of these emergency actions, but at some point we are going to need to splice out where are the various risks in following this advice, or where do we want to go above and beyond to avoid certain liabilities.
Okay, great. So then there's another question that we know is on everyone's mind right now. We're closed right now until the 30th as a state, but what people are wondering is that going to last, or are we going to all be extended longer, like we just saw yesterday where CPS extended its closure until April 20th. So Nicki, give us a sense of what are we looking at here?
Sure, and just to remind us as to where we are, and I know we've been talking about the fact that these are all act of God days. So we have been closed by governor order until March 30th, through March 30th. They are act of God days. They are not instructional days, although we do know that districts have been encouraged and are providing remote learning. As Jackie mentioned, we saw that CPS has announced closures through April 21st. I think we can all expect that the rest of the school districts will likely follow suit. I think we are anticipating an additional governor order on this front. I would anticipate that it would at least run through April 21st, if not potentially longer. I would also anticipate seeing a potential change from active God days to instructional or remote learning days. What that will look like, I think, is a little uncertain at this point. But certainly for districts that are up and running on remote learning, we would encourage to continue that practice as we wait to see what the governor is going to do. For those who are working to get that up and running, keep on those efforts. We, again, anticipate that we will not see that active God days remain in place, that we will see some change on that front, and we do anticipate that this will run well past the March 30th date.
Okay, and so just to make sure I'm kind of understanding, so what you're saying is that we are thinking that there might be some changes from where we currently are, which is counting e-learning days as non-instructional days. Potentially, if we're going to go beyond the 30th, that we might see some movement toward counting those as instructional days.
Yeah, absolutely, Jackie. That's a great summary. I think we're going to see a way. I'm certain that ISBE and the governor will come out to, with an extension of that closure, and we are likely in that process to see an instructional or remote learning day provision that allows those days to be counted for the school year, following that March 30th date.
Okay, and we did have some questions from some schools that, I think there's obviously some anxiety because everybody wasn't able to get in an approved formal e-learning program before all of this happens. Do we have any thoughts about what schools that don't have an approved e-learning program, what the landscape is looking like for them?
Yeah, absolutely. So again, we saw some flexibility on ISBE's part on e-learning put into place. I would anticipate more flexibility, more guidance on how districts who did not have a previously approved e-learning structure could get their e-learning or remote learning approved. Shelli, did you want to add something to that as well?
Yeah, I think the one piece of this is that for those districts who either were not able to in time put an e-learning program together, or maybe don't have the resources or the abilities to do it because of their communities, as the school closure gets longer and longer, and certainly if we are to the April 21st mark or longer, I think, my recommendation would certainly be that all of those districts get working on some sort of remote learning plan. I think that we're likely to see not only flexibility around the already existing e-learning programs that we have and the statutory authority for that, but also broader authority for districts to do something allowing for continuity of education that is not e-learning based. So I think the sooner that everyone gets working on that, the better in anticipation of this long school closure ahead of us.
And this is Jennifer.
Okay.
To add a little more from a special ed perspective, there's been a lot of concern about things not counting or whether certain things are worthwhile, even though we are in a period of non-instructional days and we may be going to something else. In the big picture, at the end of this, there'll be some account of what compensatory education needs to happen for special education students. And I think any efforts you're doing, whether it's non-instructional days or instructional days, it's all going to help as far as not increasing the compensatory education on the back end of all this.
That's a great point, Jennifer. So switching gears a little, still thinking about the impact of this closure on students, the recent ISBE guidance, so we know ISBE has been putting out guidance on a basically every other day basis. They've been updating their guidance for schools. And their recent update clarified that work completed during the closure can't lower a student's grades or academic standing, but that it can be used to increase a grade. And I know we've got some confusion out there about what that looks like. So what do people think about that?
Yeah, I mean, I'm certain that those of you who have teenagers know that getting students motivated to do work that doesn't count can be a challenge. So I do think that this was a reaction to a lot of schools expressing concern about keeping students engaged of all ages in remote learning or e-learning. Exactly what ISBE said essentially is that you can't use the work that you're receiving, teachers can't use the work that they're receiving from students remotely to lower grades, but they can increase grades. So they can improve grades based on the work that they're receiving. Certainly throughout, teachers can also provide feedback to students, which can be really valuable as, you know, they send off their either remotely or by taking pictures or turning in remote work to try to give some feedback to students so that they can keep motivated and keep learning and keep improving.
This is another issue that has a practical impact on special education services, because if you lock everyone in at the grades they have, let's say you had some students who are failing, special education students who are in their senior year would otherwise graduate at the end of the year if they passed all the classes but were failing at the point that we went out. It's helpful to the student, probably good for their transition plan if they had no intention of staying for transition services, to give them opportunities to increase those grades, because graduation is the end of your special education. So otherwise, both you and the student would have to continue the student's education, but there's every reason to give opportunities for increasing grades, and that will have a real impact.
All right, so what about standardized testing? Anybody have thoughts on that?
Sure. Yeah, absolutely. So as many districts were in the windows of the IAR, the state mandated testing, obviously, as you all know, that testing is based on requirements within federal law, requiring certain testing for students throughout the K-12. So I know that ISBE was looking originally to try to provide some relief from state-mandated testing. Today, we know that President Donald Trump announced that the Education Department would not enforce federal testing, standardized testing requirements for K-12 schools. So it appears, at least at this point, that issue is off the table, that districts don't need to worry about state compliance with standardized testing, so that should come as a relief to all of our school districts.
Great, thank you, Nicki. So we just switched over to a slide about the Open Meetings Act, and we have been receiving a lot of questions about the recent executive order from the governor. It was followed up by an Illinois Attorney General's Illinois Attorney General's Public Access Counselor guidance document. indicating that the OMA requirements for quorum, physical presence, and the reasons that board members can be virtually present have been suspended. So would someone be able to give us some thoughts about what should school districts be thinking of with respect to the relaxation of these OMA requirements?
Well, this is Shelli. I mean,
Sure.
I can start the conversation. Oh, sorry, Nicki, go ahead.
No, Shelli, go ahead.
So what I was going to say is I think that in terms of, obviously looking at the governor has relaxed those requirements for a really important reason, and to the extent that we've got board members who are concerned about being in a place where we would have to still afford the public the ability to come in, I think being able to handle those virtually to the extent it's in compliance with what the executive order says is a good alternative. I think being mindful, as the slide indicates, about controversial issues to the extent that we still are unclear as to the scope of the authority the governor had to change that, those requirements for having a physical quorum present. I've seen districts be really creative over the last week in how they're handling this, whether or not they're, opening up a YouTube channel so that people have access to be able to see it live as it's happening while all the board members are calling in and perhaps the superintendent is in the public space and emailing in questions for public comment that are then read aloud. I think that as this goes on further and perhaps as the rules get even stricter around people being able to leave their homes, we're hopefully going to see some legislation further supporting, in my opinion, what the governor has already done. Nicki, I don't know if you want to add anything else to that.
No, that sounded perfect, Shelli.
Okay, and then Shelli, you sort of touched on like the creativity that people have been engaging in. We know that the rules for public comments were not technically changed in the executive order, and so if boards decide to meet in person, the Open Meetings Act technically requires that individuals be allowed to, be in the room and to participate. I do believe that the Attorney General's guidance said you could have the public in a separate room, but we're on a little bit of uncertain territory here. Do we have any thoughts about how much people are going to be able to rely on the executive order and the Attorney General's opinions here?
Yeah, I think that's a really good. Oh,
I was just going to say.
I'm sorry, guys. We are.
This is the kind of area where we don't have perfect answers, and again, when individuals start to press claims where they want to challenge that their right was violated by some of these acts and some of these practices, I think the best we can say is that clearly, these things are not worth jeopardizing the health and safety of your community. So, it's one of those things where let's ask for forgiveness later. Health and safety is going to be the predominant driver, and yes, there may be challenges. We may lose challenges, but that's not a reason at this point to put the public in the room with you at a board meeting, for example. So, no, we don't have clear answers, but certainly follow the health and safety guidance.
Okay, so our one additional question that we've received a lot from clients and from participants on this call relates to vendor contracts and what are the options for payment to vendors. We know some are requesting fees. Nicki, tell us, what are your thoughts regarding this?
Yeah, sure. And our apologies for sort of talking over each other a little bit. We are all practicing social distancing. We're all on our own couches in our own houses. So we are going to continue to try to work seamlessly together. So our apologies on that. Absolutely. So vendor contracts. We know that there have been some questions raised by vendors about, paying employees during the school closures. We know that there's been a lot of inquiries, particularly from bus companies, and a lot of concern on the part of on the part of districts that those folks will be in place when we do reopen. And so, I think that you can certainly think about whether you want to enter into an agreement with your bus company or with your other vendors to make some payments during the closure to support their employees. We have crafted an amendment to a lot of those agreements for use during this time. The idea, again, to sustain the workforce for vendors during the initial closure, so we have those vendors available to us when schools are up and running again. Obviously, if we see a much more long-term closure of schools, we may not need that, but some school districts have wanted to at least bridge the gap for these couple of weeks. Clearly, the situation is fluid. There's no need to rush into entering to agreement, and we should probably see where we stand in the next 2 days. Obviously, any payments from the federal government that we see or the state will, remove any need for districts to act on their own. Right now, likely you have paid your vendors for work that they performed already, and so we have a little bit of time and a little bit of breathing room to figure this out. But again, if this is something you want reviewed, absolutely reach out to us, reach out to your counsel. If you're interested in amending your contracts to at least pay vendors during this interim period, we're happy to help you through that process as well.
Great. Thanks, Nicki. So we have been receiving so many great questions during this process. And before we move on to our employment section, I'm going to throw one of the questions that we received out there. So the question was, with respect to approval for e-learning, is it the Regional Office of Education that is the one that approves, or is it the ultimately up to ISBE who approves e-learning plans? Nicki, can you answer that one for us?
Yeah, absolutely. So it's the ROE that would approve those plans, and so they're the ones that you would be connecting with on any e-learning or remote learning plans. Again, we are waiting to see still should the state move to a more comprehensive e-learning or remote learning program, if they're going to give further direction on that front. We would anticipate that the ROEs would still play a role, but we'll probably hear more on that from ISBE.
Great. Thank you so much, Nicki. So we're going to now move on to our employment section with questions related to general employment issues. And our first question is, can teachers and other employees be required to work during mandated Act of God days?
Jackie, this is Shelli. I think this was a really open question that everyone had until we received the joint statement that came out from the Governor's Office and the Illinois Principals Association, IESA, IFT, IEA, and ISBE related to this issue. And where they came out, as I'm sure all of our listeners are already aware of, is that all school district employees on the district's payroll must get paid as if schools were functioning normally, and that means regardless of what plan your district's put in place between March 17th and March 30th, that all of those employees need to get paid for work. I think many of our districts were already planning on doing that, but weren't sure yet to do with the issue of stipends and other benefits like that. And this joint statement that came out gave us the guidance they were looking for, which is that even that stipended work that can't be performed during that time, those employees, if they would have normally been doing it, they should still get paid for that during that time period. Now, I say all that with the caveat that what happens after March 30th, I think, is still up in the air, and that we may have to fall back on either what's in your existing collective bargaining agreements or what agreements you can make with your unions as to what happens thereafter, depending upon what needs you have for your different employee groups.
Now, Shelli, are all of the unions on board with that interpretation you just described for us?
Well, as I mentioned, the IEA and IFT were both parties to that joint statement. So I think that what we're seeing, at least what I'm seeing, and I know my partners are seeing, is that there is general agreement from those two groups as to that some sort of work can be expected to be performed. What that work is, I think, is varying from district to district, depending upon what those plans were going already in place for e-learning. The two places I've seen a little bit of pushback are those unions that were not parties to that agreement. So for instance, the SEIU and ISBE, who many of the school districts across the state have employees who work in those two groups. I have seen pushback from those groups about, well, they're active God days, we're getting paid, but we don't have to work. And I think that just takes some really creative discussions with those groups as to what this means now and what it could mean moving forward if they're not willing to work with you, if you need those people working during these active God days.
Great, thank you. And now let's assume that districts are able to get their unions on board. What do you do if you just have an individual employee who is refusing to do reasonable work during a closure?
Do you mean a non-union employee, Jack?
Sorry, no, I mean either. You're a union employee, but any employee. If they're not working, sure, even though you have the right.
Well, I think if they're a union employee, working through your union leadership to try to understand what the reasoning is behind the refusal to work. And I think that could be a myriad of issues right now, and I think we have to assume good intent, and I think we're going to all get through this a lot better if we do that with one another, and finding out really what is causing that person to not perform the work, or if the union's taking a position that's not reasonable, trying to have a big discussion around why that is it's not being deemed reasonable. The issue with respect to non-union folks is, while they still have to be paid pursuant to the what ISBE has said, what the joint statement has said, I think you have a easier time talking to them, and I have yet to hear from a district who's actually disciplining someone for not working during this time period, but I think that still remains an option. But as I said, I think the first question that should be asked and really delved into is, why is this person not working during this time period?
Right. Now, you hinted at this earlier about how the joint statement provide us some clarity with respect to how to pay different types of employees, but I wanted to drill down on that a little bit. So how should school districts pay hourly staff who had sporadic hours when school was in session? Or what about those employees who are receiving extracurricular stipends?
I'll touch on the first piece. This is Shelli again about how to handle the employees who don't have regular hours. This was not directly addressed in the joint statement that was put out, but when we look at the edict that we need to pay everyone what they would normally be paid for normal work between that time period, we need to really try to take a reasonable assessment of, is there a benchmark that we can use for how much those people were working, let's say in the last month before the active God days were instituted, or do we have a sense of, during this period, how much we think they would have been working depending upon what that position was. So for instance, if we have a number of athletic events scheduled and then we know that that person would have been working those games, for instance, and really just approaching it from the most reasonable way we can. Again, we're only talking about from March 17th to March 30th, so it shouldn't be that difficult to assess that, especially since many districts have spring break during that period. But just something that you can fall back on to say, this is how we determined it, this is why, and being consistent in your explanation for all those employees who are in the same position.
Right, and on the issue of stipends, the ISBE guidance did make clear for this period, again, until March 30th, that we are to pay stipends. So any extracurricular stipends, coaching, clubs, folks who receive stipends for any of those types of work will get paid for them. One thing, though, to think about is that it was also clear from the ISBE guidance that you can expect some work in that regard as well. So definitely we're encouraging districts to think creatively. If you have coaches who are remote working, have them send out, a daily activity or workout schedule to their players. If you have, the head of the chess club can certainly send out, daily exercises or skill building. So certainly think about all the creative ways that you can use these folks to stay engaged with students. I mean, this is for educational purposes. The idea is just to keep them connected in with the school environment, keep those enrichment activities flowing so that they feel like they're getting a well-rounded, and they're staying connected with those coaches and with those club advisors who probably play a big role in their lives.
Now, what about substitute teachers? Is there guidance for how
to
substitutes under active God days?
So we have no formal guidance right now.
Oh, no, sorry, Nikki, go ahead.
No, I'll jump in, but Shelli, please add. There's no formal guidance at this point, but and certainly you need to pay all of your long-term subs. Presumably they're still doing some e-learning as well. Regarding day-to-day, we've seen districts take two different approaches to this, and honestly, I think both are potentially viable. Some districts are providing unemployment notices, essentially saying we don't have work, so that you can go ahead and apply for unemployment. Others are, though, trying to assess, particularly those subs that are, sort of regularly in their buildings that are there consistently, that trying to do, again, some sort of average in terms of their, last 30 days, last 60 days, how much they generally sub, and paying them based on their general averages. Again, no formal guidance, but either route, I think, is legally viable.
Great. Now, switching gears a little bit, we've heard a lot about taking temperatures, so I wanted to ask about where do we stand right now on taking temperatures of employees?
This is Shelli. I think that, we did see the EOC come out with guidance saying that employers can. Now, obviously, I think we're speaking primarily in this webinar to our school district friends and clients. And so for those of you who, follow me on Twitter, you already know my answer to this. My answer is I do not recommend that any of you take temperatures of your employees. There are some individuals with COVID-19 who don't have a fever. There are so many variables that employers cannot control for in attempting to do that. So in my opinion, just be clear with your employees who are still reporting to work. If they don't feel well, they should stay home, period. Do not make it negotiable with them. And I just don't see the need to be taking an extra affirmative step and putting some responsibility on any of our administrators to be taking temperatures of anybody who's coming into work.
And this is Jennifer. Unfortunately, the reality might be that we start seeing significant illness in your staff, including your teachers, and we need subs. So I think there's been a lot of concern about certain employees not getting pay, but we have to also be preparing for a possibly ill workforce. And what does that look like if we're doing distant learning? Who's going to fill in as families and students are relying on you for those distant learning opportunities?
Great. Thanks so much, Jennifer. So moving on, we've received a few questions that relate to evaluation of employees and risks and non-renewals. So let's address those quickly. So first of all, how do you handle evaluations that have not yet been completed?
Well, the joint statement itself said that all the deadlines are still in place. And keeping in mind, I know I sound like a broken record here, but that is just through the 30th of March. And so we're likely to see something that extends this part of it out or addresses it as we move beyond March into April. I think that most districts have already, completed evaluations for probationary teachers. So that part of it is probably not as big of an issue. However, there might be many districts who have not completed their formal observations, or summative evaluations for their tenured staff who are on cycle this year. My recommendation would be for those who have already have observations complete, I recommend holding the summative conferences virtually so that we can at least get those done in the time frame that's dictated by the teacher evaluation plan in your particular district. For those of you who have not completed the observations, however, I just don't think this is the time to panic. I don't think this is a thing to be focused on right now. Those teachers' ratings will default back to a proficient rating for this year. And in your teacher evaluation plan, you likely have the right to put any or all of your teachers back on cycle next year. So I think that just being really transparent about what your intentions are with your union leadership on this point and really focusing on the things that we have control over moving forward right now and not letting that be something that kind of bogs down the administration with trying to figure out how to take care of that.
Great. And then what about, this is a little bit of a technical question. So the question was, how do we deliver notice of non-renewal to a teacher if that teacher is isolating at home because of COVID?
Well, the school code requires that you send it by certified delivery, return receipt requested. I would also say in this instance, we have gotten inquiries from districts who indicate that the teachers are not picking up their mail or not handling a certified delivery. So I would say in this instance right now, making sure that you also send it by email. I think if you can demonstrate that the board took action in a timely fashion, the certified delivery went out, and there was an email notice as well, you're going to have a strong defense to any position that they did not receive timely notice under the school code. But keeping in mind that right now, all of those deadlines are still in place until we hear something different from the legislature.
Perfect. Thanks, Shelli. So now moving on to our next slide, we have a few bargaining issues. So the biggest question we've heard is, how should we handle collective bargaining currently in process where the contract expires at the end of the school year?
Well, I think, and again, this is Shelli, I think it depends on a few different factors. One being where you are in the process. Are you close to being finished or have you just started? If you are close to being done, and it is certainly if you're doing traditional bargaining, I could see a very easy way for this to be handled virtually if there's not a lot of face-to-face bargaining going on between the two groups. So I think that likely could be done. If you were doing IBB or some other sort of collaborative bargaining, I could see that being a real hindrance, because in those settings, being face-to-face with one another, being together in the same room is often how and why you're doing it that way, is to make sure that everyone is part of the process. And as much as I've enjoyed Zoom and seeing all my colleagues and friends that way in these last few days, I'm not sure how successful it'll be. Now, we may not have a choice. We may have to figure out a way for that to work. And I'm confident that you could all figure it out if you needed to. The one thing I would think we should all be considering is, do we do one-year rollovers right now? And one benefit to that would be that, boards may not feel comfortable committing themselves financially much longer than 1 year right now. And so that might be a way to push this a little bit further down the road, just bargaining kind of economics for this next year and then seeing where we're at and starting to address it all again then.
Okay, perfect. So then thinking about, sorry, my slide skipped back. Thinking about leave issues. So we've been hearing a fair number of questions about how to handle leaves during this time. So first of all, should employee absences during Act of God days be taken from employees' benefit allotments? And what do we do if they're out of benefit days?
So, Jackie, this is Nicki. I'll start in on that, and maybe Shelli can help as well. So in terms of should employee absences during Act of God days be taken from employee benefit allotments, it depends on what you're expecting of your other employees. So we know that there are some districts out there that are not expecting any remote learning or activity by their teachers or staff. In those cases, if you're not expecting your staff to be working, then you should not be deducting benefit days from employees. However, if you are, as I think a majority of the districts are expecting their staff to participate in some work, even if it's just professional development work, if someone is taking benefit days because, for example, they're ill and they cannot work, and we'll get to the issue. I know a lot of districts have the pressing issue of what if someone is on FMLA or sick leave right now and says they want to come back. But in terms of if someone is ill and cannot perform work remotely, then they should remain on benefit days and use those benefit days. Shelli, I don't know if you want to talk a little bit about what happens if someone is out of benefit days.
Well, I think it really tracks with what you, what you just said, Nicki, as to what you're expecting, what you're expecting of your other employees in terms of that. I think, again, I go back to this is the question relates to Act of God days. So we only have, a few more of those, and many districts are going to be on spring break. So I think, being as generous as possible during this time period before we kind of see what the future holds is likely, the best approach for many of our school districts. Or having alternatively the employee look to the sick leave bank, and if the union and the administration jointly govern that, maybe making some, modifications so that that's more available to people as well.
Okay,
great. And I'll pivot now to.
Go ahead.
Jackie, yeah, I was just going to pivot to the FMLA questions because I know that those are really pressing on people's minds. So particularly, again, for staff that are out currently on FMLA. So the same sort of analysis holds. If you have an expectation that staff are working right now, so you have your teachers engaging with your students remotely, you've got your paras potentially doing professional development or other things, and you have expectations of work, then someone who is out on FMLA will remain out on FMLA if they are if they have the appropriate medical certification and they are out on that leave. Now, we do have some situations where employees are asking to come off of FMLA because their condition is such that while they could not work in a school building, they could work remotely. A typical example might be someone who had knee surgery and can't come in because of mobility issues but could work remotely. Or we're seeing this quite a bit with folks on maternity leave or paternity leave, and I know that's a big question that we've gotten a number of individual questions on. So what we have been telling folks is you certainly cannot force someone off of FMLA, so you can't suggest that they start working remotely. But if someone requests that they be moved off of FMLA leave because they can work remotely, you can certainly allow for that. And in some cases, that will be of great benefit to the district if you have folks who are able to then re-engage with their students. So again, if someone, we're getting lots of emails from teachers, particularly out on maternity leave, hey, I can now work, if I can work remotely, I'd like to move off that leave. Certainly that's something that you can allow them to do and should likely in this situation. In certain circumstances, we would have requested medical certification. I think that's going to be difficult at this point. But if they have a condition where it's clear that they can indeed work remotely, you can certainly allow that transition off of FMLA leave so that they can save those days as well. So I think that's the position we're taking right now. I know folks are also aware that there is a new FMLA and sick leave act that just passed the federal government. We're not going to, given our limited time, we're not going to go into that extensively here. Actually, we're not going to go into it at all because we did a webinar on it yesterday. And all of the answers that we provided in that webinar are applicable to school districts. We talk a lot about public employers in that, which would cover our school districts. So we do encourage you, if you have questions about that law, which will impact school districts starting on April 2nd, please go to our website and pull that webinar up, pull that alert up, because that will give you all the answers to those questions as well.
Okay, and before we move on from leave issues, I wanted to ask Shelli, can you address unpaid leave? Tell us what we need to know about that.
Sure. So we have gotten a number of questions from districts about how to handle employees who are on unpaid leave. And our recommendation is to first find out, why is that person on unpaid leave? So for instance, is it unpaid leave at this point because they've run out of sick leave benefits? Or for instance, is it unpaid leave because it's some sort of disciplinary action that the district has taken? And I would say in the first instance, if it is because they have run out of sick leave and the person is not still unable to perform whatever duties the district is asking of other teachers, that we may very well not, continue to pay them for that period, so they're no longer on unpaid status, so that they're kind of on the same playing field as the other district employees, depending upon what you're expecting of them. And again, as I said, my recommendations tend to be on the more generous side during this interim period, especially. Contrary to that, however, if you've got somebody who is on unpaid leave because of a disciplinary situation, there's no reason you need to put them back on a paid status until the time period for their unpaid leave or their suspension, for instance, would have been up. So there's no reason you have to go back and change that.
All right, great. Thank you, Shelli. So again, we've received so many questions, and thank you everyone for being so engaged. Let's answer one question before we move on to special education. So the question is, do we have any recommendations for onboarding new employees without having them submit to on-site fingerprinting as part of the required background search? And can we offer positions that are conditional on a background check to be performed in the future? Shelli, do you have any thoughts on that?
I have gotten some questions on this with respect to, well, first I want to say I'm so happy to hear that people are still applying for jobs and we're still needing to hire people in our schools. So that made me, happy when I did hear that. I think that in certain instances, we don't have school kids in the buildings right now. So I think the importance of background checking for that purpose is obviously a little bit different than when they're going to be around kids. I would say to the extent, I have one district who they still did the fingerprinting and they do it locally, not at the police department, and they were able to determine, how to do it there, and the person felt comfortable wearing a mask and having gloves on and taking that person's fingerprint and making sure that that was done. I think that the idea of making it conditional is also, something that you could certainly consider. I would just be mindful if that person is going to be working with the finances of the district at all. You might want to not make that, concession to make it conditional. But again, the rules around fingerprinting and background checks relate a lot to having daily contact with kids. And since we don't have kids in the building right now, that does not necessarily have to be kind of first and foremost in our hiring processes. But making sure, of course, that it is done as soon as possible.
Okay, great. So moving to special education, our first question, I think, is one that's on many people's minds, which is, are districts required to provide FAPE during this closure?
This is Jennifer. So I'll answer that two ways. Clearly, no. The guidance is FAPE is not required when you're closed and you're not providing instruction. And we are in the realm right now of non-instructional days. So I would view the services that are being provided in the way that you do extracurriculars or anything supplementary that you provide to students. So, and that means you still have to give access, but the question is not a FAPE one. Now, the major caveat there is just like in the summer when you're not providing services to other students, there's a standard about regression, recoupment, or if the student needs to work on critical skills, where services can still be required even if no one else is getting service. So at the end of all this, it's possible that there won't have been a FAPE obligation, but you will still owe cont'd due to a regression, recoupment type analysis.
Okay, and what should schools be thinking about with respect to provision of related services during this time?
Okay, well, as we move into, so that really addressed the closures. As we move into distance learning or e-learning and other students are getting what looks like a school day, then the FAPE standard comes back, IEPs become more relevant, and you're going to start looking at supplementing with related services as part of FAPE. So there is no reason why related services can't be provided remotely. And thinking about things like if certain things are for example, a learning, you're teaching a skill. Can you teach the skill remotely? It doesn't have to be direct instruction. Doesn't mean face-to-face instruction. It can still mean the kind of instruction that you're giving on academic tasks. So obviously that's not going to work for all students, but there's a significant population of your students who will be able to get remote related services.
Okay. And we've also received a lot of questions about timelines. So what happens to timelines and deadlines during the Act of God days?
So we know that school days are suspended. These are not school days during Act of God days, so those timelines do not go forward. And however, we have not yet received any flexibility on annual deadlines. So, for example, annual IEP deadlines or other types that are hinged on calendar days, not school days. So, and in those instances, much like other topics we've addressed, we need to do our best. I mean, at worst, these timeline issues are going to be a procedural violation, but to actually violate the IDEA, there also has to be harm. Well, if you don't get an annual review in, but school's closed, it's, I would say, virtually impossible that harmed the student because there was no opportunity to implement that IEP regardless. So do your best. I would say that IEPs truly can be, I mean, my experience on week 1 is there's a good opportunity for IEPs meetings to be effective, and certainly give that a chance, because I think others will have a similar positive experience. At least now, before parents, I think you have a lot of goodwill with parents right now, and could even maybe break through on some issues where you've been the enemy for some time. Now, will that change at some point? I don't know, but now is a good time actually to do IEP meetings if you have the capacity.
And what if timelines can't be met? What happens at that point?
So that's what I was referring to. You know, if there's no school days, if there's no instructional days, there's no harm. So this is certainly not the thing that should be keeping people up at night. You know, we're going to do our best. There will be a flood then of meetings that are due at some point when things return. So obviously, to the extent you can keep that rolling bolder smaller, that would be the best practice. But if you can't, we'll do it at a future time. I will say, even parents who are initially hesitant, I was on a call with a hearing officer and a parent. The parent wanted no part of remote learning, but ISBE has been very firm with parents. You do not get in-person meetings right now, and we all need to learn how to productively engage remotely.
Well, that's great to hear. Tell us about evaluations. I know those are probably going to be a little more difficult to complete without being able to be face-to-face. Is that, what's your understanding on that?
Sure. Again, to the extent we possibly can, we want to try to complete evaluations remotely. There may be things that can't be done remotely, and we do have guidance from the U.S. Department of Education that there will, you know, some may just need to be delayed until school reopens. I think there's also the opportunity perhaps to reopen domains with the parents. Let's say the way that you had the domains drafted required face-to-face, but there would be a remote way to get that same information. Perhaps you talk to the parents, decide to revise the domains, get new consent, and then you have clearly documented a way to do it remotely. Do not do that unilaterally, though. If you're moving from the domains that have already been signed, you need to do that collaboratively with the parent. Okay.
What about, tell us about due process hearings and mediations. What can we expect with those during the closure?
So far there's not been a lifting of those deadlines, and my experience is that, like I said, we're being encouraged to do those remotely, and so I expect they will go forward. I actually have a mediation this afternoon on Zoom, so I can report back on whether that was successful. But they are proceeding at this point, and we'll see how that goes.
Okay. And how about equal minutes on the IEP? Do IEP minutes during e-learning days need to equal the minutes on the IEP, or can they be a combo?
So I think we need to think about exactly what the IEP says. So, for example, if the student got 30 minutes of a speech, and it was speech and social work, it was a combo, social pragmatic and social learning group. Okay, that was not just 30 minutes of the social worker or the speech pathologist directly talking to the student, and so we don't need that to happen now. It could be an exercise that the therapist sends out that, you know, the expectation is the student work on it at home for 30 minutes with guidance from the related service provider. I see no reason why that would not accomplish the IEP minutes. The most correct answer, if you're going to be changing minutes once we get into actual days, would be to either hold an IEP meeting or do an addendum. I know that's a lot of paperwork. Your special ed personnel is used to a lot of paperwork, and this is, again, where special ed and HR issues merge, because you need you need resources here to get some heavy lifting done to do this in the most accurate way. I think it would be best if you're going to change minutes to do an addendum if the parent agrees, or to do an IEP meeting if there's not agreement. So again, and these are not the active guide days. It's once we move into some sort of distance learning or e-learning where these are school days.
Okay. I know that we are at 1 o'clock right now. We've had so many good questions that I think we're going to keep going for a few more minutes for anyone who's interested to hear a little bit more about special education. We do know that we were not able to get to anywhere close to all of the questions we received. And again, thank you all so much for your engagement. We will try to do this weekly, so please do keep an eye out for us next week. And we are all also working and available to answer any questions with you or to partner with you during every step of this. So with that, Jen, let's do a few more questions if you're up for it. So talk to us about how teachers can update IEPs during this time. Do you have thoughts on that?
Yes, absolutely. So the easiest, now we're not making, in a way, if we're just tweaking minutes or putting in a distance learning plan, something that in collaboration with the parent, that could be the case manager calls the parent, has a discussion, or calls or Zooms, or, has some communication, and they agree to some plan about how remote learning is going to look for that student, what supports that student needs, and you do an addendum with notes in the IEP. That would be and that's if there's agreement. So not a full meeting, but it's an IEP amendment. That is allowed by the special education laws. It's something you can do. Where you need to have a meeting is where there's not agreement. So if the case manager is proposing something, the parent does not agree, then technically you need to schedule a meeting. Now, all of this is, I just want to put out there again, it's whatever you can do. I'm not saying that if you can't manage these case manager conferences or you can't manage IEP meetings, we'll be with you every step of the way as there's challenges, but I think that would really be the best practice. So case manager calls, and if there's a dispute, IEP meetings as you're able.
Okay, and then you've mentioned the Zoom meetings, and we've had a lot of questions about that. So one of those is, do we need to get permission from parents for students to participate in video conferencing? And that's it's both a special education and a non-special education related question. So maybe we could get thoughts on that from both angles.
Yeah, so I think there's a couple issues going on there. From the district's perspective, students are always invited to IEP meetings. They are an IEP meeting participant, and they should be invited. Now, if parents don't want them to participate, unless the student's 18, that's the parent's call. So I think what we're doing is, do we need to get consent? We sort of always need the parent's agreement. The parent can always exclude a student who's not 18 from a meeting, and I think that holds during these video conferences. Obviously, I think there's going to be logistics issues with us, maybe no one having as much privacy as would be ideal for what's usually considered a very private meeting. So you are going to want to have conversations with parents. So far, it seems like people are able to find a location where they feel comfortable engaging, I would say. Okay,
and then do we have any thoughts on that from just like the general education side? So really, once we're providing education to students, do we need to have permission from their parents for students to participate in that video conferencing?
Jackie, this is Shelli. I have to, unfortunately, using experiences we've had, want people to be mindful of teachers or any staff and a student having kind of one-on-one access in sort of a private forum without parental consent or at least parental knowledge. I think that our educators are doing amazing things to get in front of kids and making sure that we have continuity of instruction wherever possible. But that being said, we have rules in place in many of our schools about making sure that you are available and can be observed and interrupted by others if you're having a one-on-one meeting with kids, and making sure that the school has in place some very specific guidelines for their teachers on how they are interacting with kids if they're doing it one-on-one as opposed to kind of in a larger Zoom setting. You also have to be mindful, obviously, of kids who are potentially interacting with one another in an inappropriate way if the teacher, for some reason, is now no longer on that Zoom format or that e-learning type format in some way.
Okay, and then another Zoom question, special education related. So can related services use Zoom or other video conferencing with students for things like counseling or groups? Any thoughts on that?
Yeah, I'm so far the guidance has been that, yes, that's an acceptable format or a mode of communication to do counseling. We don't have answer for sure yet to the question about Medicaid billing if you're providing those kind of services remotely, but we do think that is one of the tools in your toolbox right now.
Okay, thank you. And we're now at 1:05. We really appreciate those of you who stuck around with us until the end. Like I said, we will plan on doing this next week, and so do please keep an eye out for alerts from us. If you haven't already signed up for our alerts, you can do so at our website, which is www.franczek.com. Thank you so much, everyone, and have a wonderful, safe, and healthy weekend.
Thank you.
Thank you.